Hi, and thank you for joining us for today's webinar on how to identify an SIBTF claim. My name is John Blake, and I'm the Director of Sales here at Gemini Legal. Before I introduce our panel, I'd like to make a few housekeeping announcements. This webinar is approved for 1 hour general MCLE credit. To qualify for the credit, please remain here for the duration of the program. At Gemini, we strive to be a resource for the entire legal community here in California. You can find past webinars, interviews, and podcasts on our Gemini Legal YouTube channel. We should have time to answer questions at the end of this. To ask a question, please do so by clicking on the Q&A bubble at the bottom of your screen. Now that housekeeping is out of the way, we can get on with introductions. I'm super excited to have two fantastic panelists here with me today. I'll let each of our panelists introduce themselves, starting with Russel.
Hi, I'm Russel Ghitterman. I'm with Ghitterman and Feld. Our firm's been in existence for 68 years. I've been practicing for almost 40. I'm board certified specialist, and we are putting ourselves out there as it relates to SIBTF to try to help the community understand the claim, how to process the claim, how to reach a conclusion for the claim, because at the end of the day, your clients are going to benefit from this claim.
Fantastic. Okay, and Ben?
Yeah, my name is Benjamin Feld, also with Ghitterman Feld, coincidentally. Also a certified specialist with the State Bar and Workers' Compensation. We started this practice group back in 7 years ago now, about 2017 now, by going to the CA conference out in Hawaii. We had a few cases that we kind of lingered with, like a lot of people, for a while, and just really started investigating how many clients have a potential SIBTF case that is being overlooked in our own firm, and really put a lot of attention towards that. And now we're trying to help other attorneys identify those same cases in their firm. So it's kind of why we're here today.
Great, fantastic. All right, so without further ado, let's go ahead and jump right in. I think you have a presentation that you want to share.
We do, and just as a warning for everybody, we're going to try and rifle through this because we figure the questions are going to be a lot more interesting than us talking. So we understand you may have questions as we go along. Hopefully some of them will be answered as we go along, but we're really going to try and get to the end as quickly as we can. So if I talk too fast or Ben moves through the panels too fast, I apologize in advance, but we would like to make sure that everybody participates as best they can.
And just clarification, John, are the questions going to come to us through the Q&A?
The Q&A bubble on the bottom of the screen, so people can ask questions on there. We can either answer them as a panelist and type in the answer, or we will answer it live at the end. And the recording will be accessible later on our YouTube channel. And I'll send out an email with contact information and a link to that. It'll probably be about a week and a half.
Thanks, John.
Take it away.
So Russell, since we can see each other, let's have a little conversation. So we understand there's some hidden benefits in the SIBTF program that many people don't understand. Why don't you explain a little about that to us?
Well, basically, the reason we call them hidden is they're just not readily apparent, and you kind of have to dig a little bit to find them. But once you start looking, they start coming up and bubbling to the surface. And probably the single biggest benefit is just the value it adds to the client's permanent disability. We all have clients who are severely disabled from work, but because of the new apportionment statutes, they're not really getting as much permanent disability as they've suffered, especially if they had a prior problem in the past. SIBTF is the bridge between what they are going to be able to obtain from the employer and also receive compensation for the actual overall disability that they're suffering from. SIBTF has been around for more than 70 years. Believe it or not, there are only 2 statutes that govern SIBTF law, but the interpretation of those statutes, for whatever reason, especially over the last 7 years, has gotten to be a little bit more challenging as it relates to how they apply to SIBTF claims. That's kind of a bit of it. Ben, you want to add something?
Yeah, so I mean, one of the things that we always look for here is some people always believe that you need to have someone that had a workers' compensation case and had a prior workers' compensation case, and you add those 2 cases together because they can't work as a result of both. And we've really tried to expand our view of where these cases lie. We're always searching for, okay, they have the workers' compensation case, but as a combination of whatever was happening before the work-related injury, the subsequent industrial injury, is it having a severe impact on their ability to perform work? Remember, it's not that they can't work at all. It's a 70% standard or greater, which we'll go into. So almost every client who's got some substantial disability usually had something that pre-existed that work-related injury. So we're really trying to take a broad view. We've seen internally, probably 40 to 45% of our cases actually have a potential investigatable SIBTF case. So,
And the reason for that is because they have a lot of pre-existing problems that you may not even be aware of. And it's only through investigation and inquiry that you suddenly learn, oh, wait a minute, my client's got these other problems that I didn't even know about. And if I add them into the subsequent industrial injury, which is the basis upon which you make an SIBTF claim, suddenly you can get to 70% pretty easily. Why don't we go to the next panel, Ben?
yeah, this is why we call them hidden benefits.
Yeah, so I would imagine your intake is pretty detailed then.
It is very detailed, but that is part of the evaluation process. Right now, we're going to focus on just identifying it, and then we'll talk about how do you get there and what do you do once you've got there.
All right, go ahead.
So basically,
I'll just jump in real quick, Russ.
Go ahead, Ben.
Yeah, but what we're going to do is kind of give a real quick overview right now, and then we're going to get to the details of each one of these sections, how you can prove each one of these sections, and some of the challenges that OD Legal and the SIBTF puts up when you are trying to meet the elements of a SIBTF claim. But it's pretty much a 1, 2, 3 step analysis to get eligibility for SIBTF benefits. And that is, you've got to have a work-related injury. It's what we call the SII, the subsequent industrial injury, that meets the standard rating requirements. Everybody always hears this 35% or greater, or 5% for a corresponding limb or member. That's what the law says. How you get there, we'll explain. There's various ways to get there, even though it may not seem on its face like it's a 35% or a 5%. There's got to be some pre-existing disability. We'll get into that a little bit more too. They always talk about a pre-existing labor disabling condition, but the statute actually talks about if there's a disability that was capable of being rated. So we're going to talk about the difference about whether or not the AMA guides change that or not. And then overall permanent disability has to be a 70% or greater. We all know what that's, a life pension, the workers' compensation claim. I will tell you from experience, 90% of these cases, if not more, are actually 100% cases when you finally start proving out what the disability is. And as all workers' comp attorneys know, the differential value between a 99 and a 100% disability is huge. Russ?
You nailed it, Ben. I
nailed it.
Yeah, 1, 2, 3. That's pretty much what we do. When we're looking for SIBTF claims, there are several different factors that we consider or look to say, is this a potential SIBTF claim? They're right there in front of you. If you've got a CNR that's exceeding $50,000, you have a possible SIBTF claim. If you have a case where the work injury is 50% or greater in permanent disability before apportionment, you probably have a potential SIBTF claim. If you have a client who's had multiple injuries, you probably have an SIBTF claim. If they've received other types of disability awards, long-term disability, disability retirement, Veterans Administration disability, any type of disability award is probably a basis for saying that that individual probably also has an SIBTF award. And then the other big flag that we look for is people who have a lot of mental or internal medicine problems, people with pre-existing psych problems, or people with diabetes, people with cardiovascular problems, any type or autoimmune disorder, any type of pre-existing condition that has, and it doesn't have to do with work at all. It just has to be a pre-existing condition. When we see that come up, we'll start looking at whether or not maybe this is a potential SIBTF claim. Now, not every claim is going to result in an SIBTF claim, but this is a great starting point for trying to identify an SIBTF claim. Can we go to the next panel, Ben? Ah, the nitty gritty. You want to start on standard rating or you want me to take that, Ben?
Why don't you take that one?
I hate this one. All right. So there are two different ways that you can get to the standard rating threshold. What we look for is a 25% WPI, because if you use the DFEC factor of 1.4, you've got 35%. The other is a 4% WPI, which will get you to the 5% threshold. So what we're looking for is, can we either make a threshold rating of 35% permanent disability, and that usually applies to people who have injuries to their back or their neck or their psych or some internal condition. If we're looking at the 5% standard, we're now looking at some type of opposite and corresponding member, but not necessarily. I mean, OD Legal takes the position it has to be the exact same body part. So if you have a right wrist with a left hand, they would say, well, that's not a corresponding member. But the standard in the law is not whether it's the same body part, it's whether the member is affected. So if you have a right wrist problem that's affected by your left hand problem, that would qualify under that 5% standard rating. The big dispute that we've been having with OD Legal and SIBTF is the application of apportionment in determining the standard rating threshold. For a long time, SIBTF took the position that when you calculated the standard rating threshold, you included apportionment in that calculation. Of recent origin, even after the case of Bookout came out, Bookout is, I'll give you the site, and I'll also provide the site in the chat if I can, John. I don't know if I can or not, but the Bookout site is 1976, 62, CalApp 3rd, 214. This is kind of the case that we look to in terms of whether or not apportionment can be applied before or after determining the standard rating threshold. To this day, we've had several cases that have come down since Bookout. Doug Redo, Robert High, Juan Anguiano, which was a writ denied case, and Ken Jensen. I also have the sites for those cases as well, and all of them stand for the principle that no, you do not consider apportionment when you're determining the standard rating threshold. You simply look at, did they make 35%? You don't count age, you don't count occupation, and you don't consider apportionment. That's the really big issue as far as number one is concerned that we're running into right now. Ben, why don't you take away number two for a moment?
Before I go there, I just want to highlight a couple of things here. So first of all, everybody always talks about, well, wait a second, the rating, we're talking about the permanent disability, right? And the law says it's before adjustment for age and occupation. So when we're doing our rating, that's part of the end of the string. But part of the logic in our argument, and what Bookout talks about as well, is that apportionment is something that happens as a defense for an employer to reduce the responsibility for a disability. It happens after adjustment for age and occupation. Whereas when OD Legal actually cites this, they talk about the reasons, the rationale, the public policy about why this standard was even there is they wanted to show that the subsequent industrial injury was a serious injury. Well, the seriousness of an injury is irrespective of how much of it is caused by the employment versus caused by other factors. So when we talk about this as being a serious injury, if it meets the threshold, it's a serious injury. We don't need to worry about the employer's defenses at this stage.
So just to be clear, what Ben has done is taken you to a place where GG&F is making arguments before the board, before the judges, and before the appellate courts on how we interpret the standard rating threshold and what it means. If you could take away one thing, just take away the idea that at the present time, the board is following the idea that apportionment does not count when you're determining the standard rating threshold. He really got into the weeds on what it is and why we take the position we do. But at present, the appellate courts haven't actually followed our reasoning, although we hope they do at some point in time. We'll see. Maybe the board will too. I thought I would transition over to number two, Ben, on pre-existing disability.
Yeah, so let me get to number two. So on number two is there's got to be some evidence of pre-existing disability. And it's got to be capable of being rated, is what the statute says. So before we have the changes in apportionment law back in 2004, oh my gosh, it's been a long time there. We used to apportion to only pre-existing labor disabling conditions. So any type of disability that existed beforehand had to be a pre-existing labor disabling condition if you were going to take that prior disability. And that's how we used to rate cases, was based on work restrictions that had to have some disability being shown from it, from either a work restriction or an objective or subjective factor of disability. But now we rate according to the AMA guides. So when the AMA guide says it's capable of being rated, all you have to be able to show is that a condition that existed before the subsequent industrial injury had a rating that could have been applied. What you don't have to show is what that rating is. You know, they always want you to say, well, we have to know what the disability was beforehand so we can add it to the subsequent. That's not exactly true. They just have to show that there is prior existing disability that was capable of being rated before the SII.
So Ben, I'm gonna step on your toes for just a second. And honestly, folks, this is how Ben and I talk about SIBTF all day long, every day. The concept that it has to be capable of rating was determined 65 years ago in Ferguson versus IAC. I can give you the cite to that. It's 50 Cal 2nd 469. The difference that Ben is talking about is the idea that when we used to measure permanent disability under the 2004 rating schedule, 1997 rating schedule, we didn't use the AMA guides to establish permanent disability. Now with the AMA guides, we can use that to establish impairment and assessment. And it actually becomes a little easier for doctors to provide information about a condition that might have been capable of rating using the AMA guides. The key part here, and I think Ben was about to transition to it, is when the doctor does that, he needs to be either relying on contemporaneous medical records that existed before the subsequent industrial injury, or on a history that will allow the doctor to provide an AMA assessment, even though there isn't a contemporaneous medical record. The easiest one you can think of is, gee, I had an amputation of my right wrist or my hand long before I had the subsequent industrial injury. Maybe nobody ever rated it. Nobody ever even looked at it, but it's really easy to be rated by the AMA guides, even if you don't have contemporaneous medical records. Ben, take it away, because you did CAIS.
Yeah, and then a step further beyond that, you know, it can be any type of condition. A heart condition is one of the most interesting ones because there's very clear ratings in the AMA guides for various levels of heart problems that can be seen based on medical records, where there may not have been anything talking about that it was interfering with their ability to do any work activity at all. It may not have been labor disabling per se, but it was definitely capable of being rated, and a doctor can look at the evidence, look at the medical records at the time and say, yeah, that would have rated as a class 2. And the CAIS case that we cite is, you know, we all have an affirmative duty to prove our case, but the board also has an affirmative duty to have the records substantiated in favor of the case. And if it's not, they have a duty to send that record out to be developed further. So CAIS basically said that still applies in SIBTF as well, and there may not be the full evidence that they need, substantial medical evidence on the pre-existing disability. They should be sending it out to go get that additional information if they need more. So why don't you talk about overall permanent disability, Russ?
Oh, golly, because that's really hard. 1, 2, 3. Basically, you take your permanent disability from your subsequent industrial injury after apportionment, add all the other disabilities to it based on Todd, and that's where you get your overall permanent disability rating. We have had a lot of success in getting almost all of our clients over 100, as long as you do a really good job of getting QMEs that are able to provide an assessment of their impairment at that time. One big issue that's come up recently, I saw this on the call listserv, and I've had a conversation with John about this and Ben, because we're actually facing this as well, And, it's just another area where we're going to end up in litigation with OD Legal, is the idea of somebody who has a pre-existing condition before the SII, but it's not permanent. It hasn't reached MMI status. And after the SII, that pre-existing condition continues to worsen until it becomes MMI and it's capable of rating. And the question becomes, when you're adding to the overall permanent disability, are you using the permanent disability that existed at the time of the SII, or do you get to use the permanent disability that exists at the time that you're litigating past the SII? In this case, we're relying on an old case as well. Dahlbeck dates back to 1955. That site is 135, Calap 2nd, 394. And Dahlbeck basically follows the argument that we're making, which is that when you're adding permanent disability, even if the condition isn't permanent and stationary at the time of the SII, you can add the permanent disability that arises out of that pre-existing condition if it occurs subsequent to the SII. I hope that makes sense.
Yeah.
It's a lot of acronyms.
I want to make something really clear. I think so much of the spike of interest in litigation in SIBTF cases arose when the en banc decision in Todd came down. Because up until that time period, everybody always tried to do what we do with workers' compensation cases. You have to you use the combined values chart to try to combine disability unless you can object or get to the doctor to say that there should be another way to combine the disabilities. And then when Todd came down, it was just, well, the law says it shall be increased in addition to. And they said, we're going to take that literally when it comes to SIBTF cases. So in addition to is we are going to add what's in the SII to what's in the pre-existing disability. The great thing there was with the CVC, it was always so hard to get to a 100% number. But when you add, it's so easy to get to a 100% number.
Right. So I'm noticing the little phrase about the role of the VE. Frankly, when we approach an SIBTF case, that's our last ditch effort to get to 100%. We only use a VE when the addition comes in underneath 100, because most of these people are 100 anyway, and then you've got to rely on the VE to get you there. But it's the rare case now that we're actually using a VE, because adding the disabilities that we're able to establish generally ends up taking them over 100%. Can you go to the next slide?
Jump
Or
one,
do you- yeah.
I want to
What's
jump
the
one more
VE,
thing on
Russell?
that real quick.
Yeah.
So we just had the new en banc decision vigil come down. And what that is telling us, beyond just what Kite said, we had to use some magic words. Now it says, okay, well, the doctor gets to just analyze the case itself to see whether or not there should be some addition that happens to the level of disabilities as opposed to using the CVC. That can be used when you're talking about what is the standard rating or for the SII. And it can be used for what is the disability for the pre-existing. And what that allows you to do is have a larger section of disability in each one of those. So when then you add those two pursuant to Todd, it just makes getting to that 100% even easier again. So just something to consider is really.
So the VE, the vocational evaluator can help you get to your 100%. Why don't you go to the next slide, Ben?
Okay.
This is one of the nuts and bolts you were talking about, John, when we first got started.
Yep.
I'm going to let Ben do this because I'm tired.
He's tired already.
I'm old.
Speaking for 30 minutes. Come on. So there's lots of different stages along the way. John brought this up earlier. The intake is super, super important. And, we all try to do the best intakes we can, but we're also constrained sometimes with the time limits throughout the day. But at this stage, especially when you're fresher in time with the individual's memory, you should be looking for not just what's happening with the workers' compensation claim, but what happened before the workers' compensation claim. We have this fear. Doctors have this problem all the time in learning about SIBTF because they're always so focused on what's related to the work comp case. I don't want to know about what's going to be apportioned to, or, we want to try to avoid those things, where this is just the exact opposite. We really want to identify those early and sometimes even explore those in the workers' compensation case in chief when it's when it's something that could be appropriately added later on in the SIBTF case. So the intake is huge. Where do they treat? Let's get a full history, the best of our ability. You know, with this work comp case last 5-6 years, by the time you get to the SIBTF case, those records may not be in existence anymore. So the sooner you can go out and get those records, the better. Constantly monitoring medical records. I will tell you my favorite section of the medical report now in a workers' compensation case is past medical history. I love that section because that's helping me identify the SIBTF case early on, so I can put a marker in our file that when this case in chief closes, I need to go out and pursue what that additional future, that past medical did to the case.
Ben, just a quick follow-up on that.
Yeah.
To remind everybody, this is where getting the records is like critical. And the upside is we don't have to pay for it. Get every record you can, because as the more records you have, the easier it's going to be to prove your SIBTF case. So when you're doing that intake with your client, you're going to want to get all the healthcare providers that they've seen, regardless of the reason why, and then go get their records. At the end of the day, it's all about establishing a foundation for, and in this case, when we're looking at this, it's mostly about establishing pre-existing disability and overall disability. The overall disability we'll get to with the QME, but the pre-existing disability, they're going to need those records. And I can't stress enough how important it is to have a reliable partner when you're looking to get records. Go ahead, Ben.
Okay. Then you get to the resolution of the workers' compensation case. This is one of the most important aspects if you are looking at a potential SIBTF case. We get referred cases, and sometimes what will happen is we'll get a referred case that's been settled before there's a finding of industrial causation for the work-related injury. That creates problems when you're trying to have an SIBTF case, because now you might have to go out and still prove industrial causation in your workers' compensation case because it requires a subsequent industrial injury. You want to know sometimes what the level of permanent disability is, and sometimes you want to make it as vague as possible. And usually the defense attorney in the workers' compensation case doesn't really care so much about what the language is. And while that language may not be binding on SIBTF and OD legal, it can be persuasive, especially when the judge who signs the order awarding the CNR is the same judge who's handling the SIBTF claim, because they'll look at, well, this is what I've already ordered. So they kind of follow the same logic along that way about what the value of the subsequent industrial injury is, or what the overall disability was before apportionment, various factors. So you really want to look at the language of the CNR, and it's like playing a game of chess, trying to stay 2 steps ahead about, well, what will help me take those steps to prove any of those 3 benefits that we were talking about earlier that need to be demonstrated, the 3 prongs. And then additional discovery. Once the case is complete, the workers' compensation case, we don't just file an SIBTF claim and go to trial in the SIBTF and resolve the claim. You still want to do discovery. There might be additional information that you need to use to fill in that piece of the puzzle that's not there. It could be information on prior disabilities. It could be information on credits, or to defend against credits that might be argued. So there's additional discovery that needs to happen. So you definitely need to have a game plan about how you're going to prove each of the 3 elements and what you're going to need to fill in the gaps of what you don't already have in that regard before attempting to try to resolve or go to trial in those cases.
Just to be clear, you don't have to go out and get a separate QME. If the forensics and the underlying workers' compensation case are solid, you might be able to rely on that reporting, at least insofar as the medical questions are concerned regarding pre-existing disability and overall disability. We just often find that we're using QMEs for those body parts that were not actually considered within the workers' compensation claim.
And you brought up a great point, Russell. You brought up a great point is to understand that while in workers' compensation, we're required to use either an AME agreement or then go to a panel QME, those laws do not apply when it goes to an SIBTF claim. It's the way we used to do discovery, where we can go get whatever QME, whatever forensic evaluator we need. And the best part, the reason so many of these doctor groups out there are getting very involved in SIBTF, it's OD Legal pays. They don't dispute. They'll just pay the bill. So we're able to really go out and say, okay, who is the best doctor who understands that they're not trying to talk about the subsequent industrial injury anymore. They're supposed to be talking about the items that predated the subsequent industrial injury and addressing how those were capable of being rated before the work-related injury, and really focusing on those areas. All right. Oh, this is our favorite now.
Well, clearly, because we got a published decision on it.
So I call it the 11th commandment. SIBTF shall be reduced. They do get a reduction. They get two reductions. One's under Labor Code Section 4751, and one's under Labor Code 4753. Under Labor Code Section 4751, you don't get monies for the SIBTF benefit when you're getting money for permanent disability and the subsequent industrial injury claim. So they get an offset. They used to call it an offset. Now they just call it reductions. But they get an offset essentially for the monies that you received for the SII.
It's not that money's received, it's the money due. That's what the statute reads.
Right, and I was going to go into it. This is what they say. And it's also about, there's always arguments SIBTF makes. We'll say, well, the CNR was $300,000. So we get a reduction for $300,000. They don't get a reduction for $300,000. They're going to get a reduction for the value of the permanent disability from that claim. And we're going to argue about whether or not they get it for the medical treatment expenses that they got paid for, the attorney's fees, other dollars for other benefits that may have been included, the items that were waived, anything like that in the subsequent industrial injury settlement.
So Ben, I'm just gonna small war story about this, just so we kind of run into this in two different cases where we settled our client's case for a very large sum of money. And because of the amount of the money, OD Legal was arguing, well, naturally, a lot of that money has to be due to permanent disability. The problem was the actual permanent disability that arose in the SII was pretty low. I think one of them was 20% permanent disability, and the other was like 43% permanent disability. But in both of those cases, their CNRs settled for a large amount of money. And
They were 7 figures, yeah.
Well, I didn't want to go there, but yes, 7 figures, fine. But the point being that OD Legal says, look, the client's getting so much money, it can't possibly be just the amount that is identified as the permanent disability. But the way the statute's written, all they get is what the permanent disability is for the SII. This is when you want to argue apportionment. This is when you want to argue that the exact opposite of what you do in the underlying case. In the SIBTF case, you want to argue as low as possible as it relates to the SIBTF for the SIIPD, because that just reduces the reduction that SIBTF gets. And unfortunately, the way the law is written, the way the statute's written, the way it's applied, they do get to use all of the permanent disability, not just the amount that goes to your client. So if your client gets a $20,000 PD award and there's $3,000 for attorney fees, leaving $17,000 to the client, SIBTF still gets the credit for the whole $20,000. Why don't you go on to 4753, Ben?
Before I get there,
Or not go on to 4753.
Don't tell me to go on, because I got something else to add. We were talking about before how important the language in the CNR is, though. This is one of those areas where a CNR can be extremely helpful, because if it's in dispute about whether or not you're selling your case based on 100% or something less than 100%, and it's vague, there's an argument that SIBTF can be raising that they're not entitled to an SIBTF case at all because they got 100% in the workers' compensation case. That's why they got such a large CNR. And sometimes there's a dispute, sometimes there's discovery that has to happen. if you get a stipulated language in the CNR that this is based on a 68% permanent disability and are able to demonstrate factors why that could have been a result had you gone to trial, they're going to have a much harder time establishing the basis for a higher offset or credit. Really important to think that through when you're selling your CNR of your work comp case. So then you go to the 4753, and this is really interesting language. I'm always a little bit questionable about why they limited it in this way. But it says they get a credit for monies paid on account of prior disability. And prior, if you have a prior work comp case, okay, that makes sense because they don't get the permanent disability for that because they already got paid for that. That makes the sense. It was a prior disability. They already received it.
Except for the attorney fees aren't counted in that calculation.
Attorney fees aren't calculated.
It's about money received, not about money due.
But this was extended beyond just the prior workers' compensation case to other disability benefits, Social Security disability, disability retirement. And so if you get a Social Security award as an individual, and we don't know what was the basis for that Social Security disability award, some of it could be based on the prior disability. Some of it could be based on the subsequent industrial injury. But the way the law is written, they don't get to take any reduction for the portion that's on the subsequent industrial injury. So there's a fight, there's a dispute, because oftentimes these other disability benefits don't break things down in the way that this law kind of wishes them to do so. And the case that we just went up to the Court of Appeals on and got a published decision in is the case of Vargas. And in that case, the SIBTF was arguing, well, we approve the eligibility for our client, and then we have to demonstrate to them how much of that should be reduced because of the because of the pre-existing disability. And we said, wait a second, we're the ones who are showing eligibility. It's SIBTF who's seeking the reduction. So it should be their burden of proof to demonstrate what that reduction should be. And then we can rebut whatever they argue. And the Court of Appeals found in our favor in that regard. So what we know from the Workers' Compensation Appeals Board and from the Court of Appeals is we have to help provide the information about other disability benefits they may be getting. So if we know that they're getting Social Security, we need to help them obtain that information. Our client can generally get that information easier than SIBTF can. Same for the disability retirement. But what we don't have to do is demonstrate why that should be contributing to a reduction of their case in any way. The SIBTF needs to show it. If they can't, they don't get the reduction.
So
You want to add, Russ?
yeah, I want to go into the weeds a little bit on this because it's really interesting, this issue that's come up as it relates to reduction, who bears the burden of proof, and more importantly, how do you prove it? Because this question actually came up to Ben from the justices in terms of showing how do you show the percentage that's due to pre-existing disability versus the percentage that's due to the SII. Our argument is principally based on the idea that pretty much if you get an SSDI award or you get a disability retirement award, it's because of the SII, not because of the pre-existing disabilities. But when you're faced with a prospect where you might have to produce evidence to show that percentages, you're going to need somebody who knows a little bit about Social Security to look at the evidence that the Social Security system reviewed and offer an opinion about the basis and the reason for the SSDI award. In Vargas in particular, and Ben, you have a better handle on this than I do, but in Vargas in particular, she received her SSDI award without an evidentiary hearing. The only evidence we had that she was getting SSDI benefits was a letter from the Social Security Administration saying, congratulations, you're getting SSDI benefits. It doesn't say why she's getting them. Now, as it happens, if you have somebody that's familiar with Social Security, like Ben Feld, because he's the one who knew it, in Nancy's case, she was most likely going to be getting that SSDI award because she scheduled out based on a sedentary work restriction, her age, her skill set. Have I got that right, Ben?
Absolutely.
Right. And consequently, the SSA doesn't go any further than that. And what was really interesting about Nancy Vargas's case is that she actually applied for SSDI benefits before her SII. But the award only went back to the time period that started after her SII. I have one other thing about
Okay,
that.
go ahead.
I'll let you go. Because hidden within the Vargas decision is something that attacks the standard formula that SIBTF uses for determining what percentage is due to pre-existing disability and what percentage is due to the SII. Typically, let's say you have somebody who has 100% permanent disability and the SII rates at 40%. Well, that would mean that the other 60% is due to some pre-existing problems that that individual had. Consequently, what SIBTF did was say, okay, well, we'll take a credit for 60% of that disability. And that was the way it was for quite some time until some law firm got in the way of SIBTF applying that formula. Us. So what happened was in the Vargas decision, the appellate court said, no, that is not the way you establish the percentage that's attributable to pre-existing disability. It's an independent evaluation and determination. Ben, you want to run with this a little bit?
No, I mean, that's exactly what I was going to talk about, is that there is no formulaic approach anymore. They're going to always try to argue that without illegal, and you say that's not good enough. They really have, it's everything that's coming down from the board these days. It's Escobedo, it's Vigil, it's this. You can't just use words or formulas. You actually have to have facts and opinions to support what you want to argue. We're lawyers. And the mere use of words or formulas is not how we're going to do this.
I noticed there's a little blurb about no credit for VA benefits, so they don't get a reduction for that. But somebody asked a question about, well, if you're 100% from a VA injury, how do you get an SIBTF award? Ben, would you like to explain how that happens?
Well, very easily. You know, the VA benefits, the disability from VA benefits is not just for things that happen while you're in the VA. So some of them might be later on, why part of your subsequent industrial injury, some may not. Or you still may have been able to find a job later on, despite the fact that you're 100% disabled for the VA, and you get your award there, and they get no credit. And that goes back to the reason that they started SIBTF to begin with. It was supposed to encourage employers to hire veterans when they came back from World War II. So this is basically that they get to keep them both. It's a benefit for veterans. All right, so we're gonna move on. Getting close to the end, so you can get some questions in. Why do we do this, Russ?
Oh, well, because it has a huge effect on the client. I mean, just massive effect. They might get $30 or $40 or $60,000 in permanent disability in their workers' compensation case, and then they're receiving hundreds of thousands of dollars in an SIBTF recovery. Can't tell you the number of clients who talk about how we have changed their lives as a result of being able to pursue and obtain this benefit. So this is just such an impact on their life. If you could imagine for a moment, even somebody who has like an 80% permanent disability, that it's paid out at $290 a week, and then they get a life pension. But if you can get them to 100%, you're talking about their TTD rate for the rest of their life with COLAs. The amount of money that goes to the injured worker is just beyond imagination. And really, this is where we can do a service to our clients by identifying these cases and pursuing these cases. Go ahead, Ben.
So the last subject we're really going to talk about, and we're going to try to do this somewhat quickly, is
Good luck with that.
how long do I have to file this? You know, we showed you the two statutes, and what's so interesting is within those two statutes, there is no limitation from when you can file an SIBTF claim. There's nothing. So the Supreme Court said, well, we need to step in. We need to help. So in two cases, in Talcott and Baca, you've probably heard those cases. They always talk about those cases. They say, okay, we're going to provide some limitations. I love when they argue it's a statute of limitations. I'm like, yeah, it's missing one thing. Oh yeah, a statute. There is no statute. It's merely a timeliness argument, somewhere in between latches and a statute of limitations. But they basically have said, okay, look, if it's within 5 years of the date of injury where you resolved your case, you pretty much you're going to use the petition to reopen rules. You got to do something within that 5-year period. Trying to get an increase in benefits, we're going to kind of put you on that 5-year track. The argument I'm having with OD Legal right now is, well, what if it's a CT claim? As we all know, pursuant to CT claims under 5412, that date of injury might be much, much later than when they stopped working, but that's the date of injury for purposes of statutes of limitation. I argue it's the same thing here for the 5-year period.
And the board has followed that argument in redo.
Very much so. So now you're talking 7, 8, 9, 10 years after they last worked, following an SIBTF claim potentially. But the other side of this is if it's outside of the 5 years when they finally resolve the claim, the question is, okay, what's a reasonable period of time from which you should be able to still file a claim? Because you may not know if they meet the qualifications for an SIBTF benefit until you ultimately resolve the case. They might be 100%. So there's no SIBTF. They might be something that in the 20% range. They're not going to meet the 35% threshold. So until you get some finality, you don't know. And the way the law is written is they said, okay, it's kind of like a 5412 argument, at least that's how we look at it, is that the employee has to have some knowledge of a substantial likelihood of entitlement to benefits. And once they get that knowledge, that's when that timeliness starts. And then they've got a reasonable period of time thereafter in which to do something with it. The problem is they haven't really established what is knowledge for this purpose, what's a substantial likelihood of entitlement to benefits, and what's a reasonable period of time. So our argument is we're pressing these cases to see, okay, well, what is the scope of the limitation? We still don't know. We still don't know. I just got a writ denied case recently in this case of Oriana where she had filed it 7 years after her resolving her claim. They said that's probably a little too long. Okay. Well, how long is too long? So we're still trying to get that answer. We really don't know that answer yet. We will someday. Russ?
I concur.
Okay. So in conclusion, we've basically spent a lot of time here in our firm, my law partner and I, handling SIBTF claims. As a matter of fact, we have an entire workers' compensation department, but outside of that, we have an SIBTF department. We utilize SIBTF analysts to review our cases. We talk about these cases often. We do a lot of lectures like this. We're here to help people learn how to do SIBTF. If it's something that they don't want to do, we also are happy to take on those cases and pay referral fees on those. However, we can help a firm learn more about this subject and help their clients get these benefits. Because again, these are hidden benefits, and leaving these benefits on the table is just such a downside for your clients' potential rights to make them as whole as possible financially.
And just so everybody knows, we don't do it pro bono. We actually get paid to recover benefits for SIBTF claimants. We get a portion of the retro payment that's made because invariably, almost always, the client's going to be entitled to some retroactive benefits up to the date of the award. And then there are periodic payments that are paid every 2 weeks for the rest of the client's life. SIBTF doesn't commute. It only pays for as long as the client is alive. They only really, my experience is they only settle CNR cases when there's a really hot dispute, but they'll usually stip cases where they're going to be owed money. The fees can range anywhere between 15 to 25%, depending on which judge you're in front of and what arguments you make to the judge in terms of your request for the fee, as well as providing background information, consistent with the policy and procedure manual if you're asking for a fee above 15%. Generally speaking, the judges will almost automatically award a 15% fee without even thinking. We tend to regularly request a higher fee, primarily because of a lot of work that we do in this field. But why don't we get to some questions?
Yeah, I was going to ask you some questions here I've got in the Q&A. Do we take care of that,
Great.
John?
Yeah, go ahead. Go for it, guys.
Okay, so let's see. If an injured worker has 100% VA disability and then a subsequent work injury case, so I think we addressed that one. How well is SIBTF funded?
I could take that one.
We're doing it annually.
Yeah, so while they have a budget, it's important to remember that the SIBTF is part of the workers' compensation system, and the workers' compensation system is a completely self-funded organization. All of the money that goes to pay the judges, the clerks, and anybody else associated with the workers' compensation system comes from workers' compensation insurance premiums. We are funding the SIBTF. What we don't know is how large is their reserve account, because we suspect they've been sitting on decades of SIBTF money without distributing, and now all of a sudden they're starting to distribute. I think our goal is to make them bankrupt, is it not, Ben?
No.
All right.
This is a great question for you. Recently, I was told that OD Legal has marching orders to challenge any argument or citation. How can I refute that?
Trial.
Exactly. This is not all these cases resolve. As a matter of fact, a lot of them don't resolve. Or if they do, they may be resolving too prematurely or for too little money, because there are maybe some hotly contested issues that do have to be litigated. And it's sometimes tough. Sometimes you have to educate the judges, because they're not usually very aware of this.
I'm going to try and go through these questions as fast as we possibly can.
Sure.
STIP settlement B SIBTF cases, absolutely. Almost all of our cases are STIP. If you do the right process of creating the foundation and laying the foundation and developing your evidence, SIBTF will roll over and STIP on the case. Be certain to ask examining physicians to apply kite. You don't really need kite within an SIBTF claim. What you need is establishing levels of permanent disability for each pre-existing condition based on contemporaneous medical records. Height is useful in a workers' compensation claim because you're trying to increase the permanent disability by adding together multiple disabilities within the SII. But within the SIBTF claim, they're already added under Todd. Do you typically wait to file the SIBTF case until after the award in the case in chief? Typically we do. There are occasions where you may not, but typically we do. Ben, do you want to go on?
Sure. If your SIBTF QME wants further additional diagnostic studies on the body parts that he or she is evaluating, does the SIBTF defense usually agree to pay for that diagnostic workup? I have rarely ever had any objection or argument to any medical discovery I need, as long as it's reasonable.
There's a really interesting question about prior psych injuries. If the applicant did not obtain impairment in their SII injury due to labor code not allowing compensation. I have a couple of cases right now where this is going to be a very interesting question in terms of, does the psych PD in the SII apply to the SII PD even though they aren't allowed to recover money for it? And certainly if there's a prior psych condition, you'll be able to add that in the pre-existing condition section. But it's really interesting because sometimes you need that psych PD in the SII to get yourself up above standard rating threshold, or even more, that it helps you to get to 100%. So it's that's a really interesting question, and I don't have a more specific answer for you.
There's two questions I want to get to on here real quickly. One, is there any case law that they don't get a credit for VA benefits? Better yet, it's in the statute. It specifically excludes it in the statute. Can you rely on an SSDI award to show that a client is in fact 100% disabled? Well, interestingly, the SSDI award does not say that they're 100% disabled, that they don't use that terminology. It shows that they're not capable of suitable gainful activity. In workers' compensation, typically we're using medical disability to establish somebody's inability to perform work, where we use vocational disability and Social Security. But whenever you're rebutting the AMA guides, Using a VE in workers' compensation, you're now using vocational disability. So a prior Social Security disability award can be helpful in supporting that argument.
And this is actually one of the issues that came up in Vargas that we argued before the appellate court. The disability is not evaluated the same way in a work comp case as it is in an SSDI case, as it is in a disability retirement. They all use different ways of evaluating disability, and consequently, one does not necessarily equate to the other. You can have 100%, you can have an SSDI award and really low disability in a work comp case. And conversely, you can have a really high workers' comp disability and have no SSDI award. It's confusing, but it's the way it is. Can OD Legal get a reduction on monies awarded from a civil action that resulted in disability? That is an excellent question, and we are in current litigation with SIBTF about this very issue, because our argument is that civil damages is not the same thing as permanent disability. There is some dicta in Hansen, which was a case that talked about reductions based on SSDI, that suggest that SIBTF can obtain a credit against recovery that's obtained in a PI case towards the SIBTF benefit if it pre-existed the SII. We haven't had a case that's gone up to the board on this issue, but I think part of the problem is that a PI case incorporates a lot more than just disability. And I suspect the courts will find they do get a credit, but you have to prove what percentage of the PI recovery is due to the disability. We haven't gotten there yet. And most of the time we just cave with SIBTF on this issue, because most of the time the PI recoveries are practically nothing. It's the rare case where you're looking for an SIBTF award for somebody who completely got smushed in the the PI case, because, well, they're usually pretty severely disabled when they've got that.
Do we have time for a couple more, or are we out of time?
We're actually out of time. If you guys want to grab one more, I'm copying and pasting all the rest so we can try to answer them after.
Awesome. I'm going to ask you one more, Russell. It's from Larry Stern, so I figure you'll love this one.
Oh, sure.
Is there any case that if you have a pre-existing prior workers' comp injury rated under the old PDRS system, say at 30%, and a new injury rated under the AMA at 70%, that you can add the 30 and 70 without getting into the apple and orange argument, so you are at 100%?
Yeah, that's the best part, Larry. That is absolutely the best part. Whatever the PD rating is that occurred before, you just add that number to whatever happens in your SII. So if your SII is rated under the AMA guides and your pre-existing permanent disability was rated under the old system, it's not an apples or oranges discussion at all. You just add them together under Todd, and that's how you'll get to your 100%. It's a great question, though.
All right. What I'm going to do at this point, first of all, I want to thank both Ben and Russell for hopping on and sharing all this information. I know there are a whole lot more questions on here. What I did is I copied them down, and I'm going to send them over to Russ and Ben, and hopefully they can take a little time to answer some of them individually, and I can send them out with the follow-up. The other thing that I'm going to task Russell with is getting me all those citations so I can put them in the follow-up as well, so everybody that's on this can have them. Also, I'll send out in about a week and a half or so the link to the recording, and you'll get a separate follow-up with your CLE information on it as well. So again, thank you everybody for attending. Thank you mostly for our panelists for helping out, and I hope to see you guys on the next one. Thanks everybody.
That's great. Thanks, John, for inviting us.
All right, thanks.
Oh, hey, John,
Yeah.
Can we let people know that if they want to reach out to us or they have questions, they can just contact us directly. Our email addresses are russell@Ghitterman.com and benjamin@Ghitterman.com. Really easy
I'll
to
include that in the follow-up as well.
We're happy to respond and help anybody with evaluation or process or anything like that.
Wonderful. Well, thanks again, guys, and I appreciate everything. Take
Our
care.
pleasure.
Have a great week.